Hello, this is immigration attorney Curtis Morrison, based in Southern California. I have a frequently asked question that I would like to address in a video. The question is this: can I participate in mandamus litigation and not use my name, or not use my real name, or just use my initials because I am concerned about privacy? It is a great question. Privacy is important. First, if you are a minor or for your children that are participating in a litigation, we do not use their real names anyway. We just use initials. We use initials. Courts like initials for minors under 18 years old. So don't worry about that. We want their real names and we need their real names, but in the court papers, we will just use initials, okay? Now, if you're an adult and you want privacy and you want to use a pseudonym, it's pseudonym. Pseudonym. I forget how to spell it. So if you want to use a pseudonym, the procedure with the court is we file a motion for that. And we have to charge for it because it is a lot of work. The court has some settled law on this issue. Basically, here's the settled law. A party may preserve his or her anonymity, and they can be anonymous, in judicial proceedings in a special circumstances when the party's need for anonymity outweighs the prejudice to the opposing party, in this case the government, and the public's interest in knowing the party's identity. Okay, so, and then there's some more law that was from the Ninth Circuit. There's some more law that says where pseudonyms are used to shield the anonymous party from retaliation, like you're scared that someone is going to retaliate against you if they know that you are in a visa process, like the country that you are immigrating from, or your employer, or your family, or something like that. The district court should determine the need for anonymity by evaluating the following three factors. The judge will look to three factors to decide whether or not the retaliation warrants the use of a pseudonym. The first is the severity of the threatened harm, whether your life is in danger. Really, that is like the worst harm there could be. The second is the reasonableness of the anonymous party's fears. Are you being reasonable, or are you just wanting to be secretive about who you are? And third is the anonymous party's vulnerability to such retaliation, if you are actually vulnerable. An example for that is like you can't say you are fearing the retaliation of this country's government if you're not actually located in that country and you're located in a third country or something like that. So there's a whole bunch of case law we have on this actually, and it is difficult to get. Here's what I have to say. If you want to proceed with using a pseudonym, sometimes we use common pseudonyms like John Doe or Jane Doe. We will have to file a motion for that. We will have to charge extra for that. And your best chances of success is if you are actually, your life is in danger if your name gets on the internet associated with this case. If that is the situation, we probably should talk about a pseudonym for you, because I do not want anybody's life to be in danger. But if you just want to keep it a secret that you're on the case and do not want to show up on Google, I do not think a pseudonym motion would be successful or practical for you to file. I hope that answers the question. If you have any specific questions about a pseudonym motion, you can always hit me up on Telegram or WhatsApp. Thank you.